key, right? And I'm going to be facilitating this workshop, this webinar today, as we go through and try to answer some of the critical questions around knowledge ownership and copyright, and authorship of work that has been generated with AI. I mean, there's a lot of myths, right? There's a lot of speculation, and if you're in the academic space, you probably ask yourself, do I really own this work? Or does AI own this work? Does the ChatGPT own this work that I've generated? But today we're going to draw on examples from the US, UK, EU, and other African countries. But our discussion is centered around South Africa, right? Looking at trying to understand what really does it mean to own the knowledge generated from AI within the South African context. But we're going to benchmark it with what is happening elsewhere. Right. So, like I said, my name is Dr. Moringa, and I'm a researcher, right, in the field of AI and communication. Also, my research interests are around media representation and women politicians within the sub-Saharan context. Right, so I'll be taking you through this. My previous work includes being part of the UKZN AI task team in 2025, and I've also been doing a lot of work with advising deans, academic leaders, and faculties in terms of how we navigate the ethics and responsible use of AI, especially in the space of examining theses and dissertations for masters and PhDs. Right, so we're going to look at key 15 things, right, very quickly and briefly, right? Then we go to discussions and hear what the colleagues think about the topic. So the first area will be on historical origins of copyright. We'll also talk about what does it mean to own knowledge, right? We'll also look at the transition from printing press to generative AI, right? And looking at what has changed. We're also going to discuss the issue of human authorship as the foundation, the AI output problem, right? The USA strict human authorship. What does the USA say? What does the UK say? What does the European Union say? And what is the African context on copyright principles say? And then we bring it back home to South Africa, where we speak about copyright and originality. But the key question that underpins this discussion today is who owns AI output in South Africa, right? Who owns AI output in South Africa? But this discussion goes beyond South Africa because there's a similarity across within the sub-Saharan context in terms of what the copyright law says about ownership, right? So that will bear resonance in most African countries. So wherever you are joining from, right, the discussion will still be relevant for you, right? So also looking at the platform terms and copyright law, what does the platforms that we use in the AI platform, what do they say about the ownership of the knowledge that we would have generated, right? We also talk about the issue of AI as a ghostwriter, right? Do we categorize AI as a ghostwriter, right? And what studies have research has shown, right? There are quite a number of studies that have been done, but we'll focus on two, right, of interest, right, that speaks about what the participants and what academics and researchers and students think about AI as a ghostwriter. Key interesting outcomes that came out from there that we'll discuss, and also talk about training data and rights of creators. Then we suggest possible reforms in the context of South Africa and other African countries, right? So copyright, as we know it, right, did not emerge simply to reward ideas, right? It developed to regulate the production, the circulation, and commercial exploitation of expressive work, right? That was the purpose and the foundation of where copyright came from. So copyright does not protect raw facts or abstract ideas, right? It protects the particular expression of those ideas, right? How did you explain those ideas, right? So this distinction is crucial because copyright does not generally protect raw facts, ideas, abstract ideas, and it protects the expression of these ideas. And the AI question, therefore, it requires us to separate knowledge generation from copyright ownership, right? And I think there is a huge confusion amongst people, scholars in all aspects of society, in terms of not knowing the distinction between knowledge generation, which most of us do on AI platforms, from copyright ownership, right? So that will make that distinction. So in this case, a person may use AI to generate useful knowledge, right? But this does not automatically mean copyright exists in the output, right? I think this is clear. So you may generate knowledge, right, on any platform, right? But that knowledge that you've generated does not automatically then mean that there is copyright, right? That you need to that exist in that output, right? So this historical logic of copyright has always been tied to human creativity, labor, originality, and issues of incentive, right? So when we are looking at it, we're saying that the basic logic or the foundational understanding of the issues of ownership, of owning that expression of ideas, how that idea has been expressed, right? It was centered around, did it come from human creativity? Was human labor involved, right? And is there originality, right? And in the issue of incentive, right? To incentivize the one who has created that information. But now that was pre-AI, right? Now then we are in the age of AI and agentic AI, and now the question is, generative AI unsettles that foundation because it produces work that appears expressive without necessarily involving human creative authors, right? So it's expressing AI without much work from an author or an individual or human. It can actually creates that information that the copyright says it is expressive. It can express those ideas, right? It can express those ideas. But now there is another question, that there is no human creativity involved in that creation of what, of information. Then where then does the AI leave us, or the AI generated work, in terms of meeting all the boxes or the criteria of copyright, right? So you see now that generative AI then unsettles the definition of copyright or ownership, right, is defined by copyright or various copyright laws, right? So, but the question now is, what does it mean to own knowledge? Right? What does it mean to own knowledge? I would say that owning knowledge is broader than owning copyright, right? And knowledge may be collective, it might be socially inherited, it might be publicly available, it might be institutionally controlled or culturally embedded, right? But copyright protects specific expression of that knowledge, right? Copyright protects the specific expression of that knowledge, where ownership may now depend on authorship, right? Depend on employment, right? Or who authored the work. That's where ownership comes in, right? If you are working under an employee, an employer, right? If you create this kind of work under his employee, right? That work then belongs, it is owned by the employer, right? Then the commissioning agreements, what agreements are there when you author the book? The commissioning agreements in terms of authorship, the book now determines who owns this work or this artwork that you've produced. Then institutional policies, if you do work at this university, that thesis or dissertation belongs to this institution, right, regulated by the institutional policy. Then our platform terms, like for example, your ChatGPT and OpenAI and Anthropy, they say they do not claim ownership of the work that has been generated by the user. They say all ownership, terms and rights and everything belongs to the one who has generated, right? So that's what the terms of the platform say, right? So that all brings the issue of originality, into question. And there are also issue of statutory copyright rules, right, that also inform or regulates who owns that work. So users often assume that prompting AI means owning the output, right? That's the go-to argument, right? Say, oh, because I prompted this work, and automatically now I own the output, right? Now that we say there's a difference between owning knowledge and generating knowledge, right? Generating knowledge and owning knowledge, right, is two different things. You might have generated that information from an AI output, but now the question is, can you claim copyrights of that which you have generated from AI, right? So this assumption is leaves us in a legal uncertainty, right? Where you say, because I've prompted this work, now this means I own it, right? Now the question brings into question the issue of, if you generate an image, right, on AI, any AI platform like we are doing these days. Now the question is, can you file for copyrights of ownership of that image, right? Difference from when you generate a document, right? But we'll get there. So platforms terms, like I said, that they assign rights to the user, right? For your chat GPT, your generative, almost LLMs and generative AI platforms, they assign rights to users, right? But they cannot always create copyright. Right? The fact that you have been given rights to use, to publish this work and to do whatever you want to do it. Colleagues, there's somebody whose mic is unmuted. All right, Otunu Kabe, can you please mute? Otunu Kabe, Otan Kabe, can you please mute? Thank you. Right. So that's where we are, right, in terms of knowledge ownership. So we're saying that even though the platforms may give you the rights, right, to publish the work, to reuse the work, they cannot always create copyright. They cannot always create ownership to say, you claim that I own this work. Now, but the key question, the fundamental question is that, does the person who prompts an AI to become an author, right, a commissioner, an editor, or merely a user, right? So where does that place you? By merely prompting an AI platform, then you get an output. Do you then become an author, or are you a commissioner of that work? Are you an editor of that work, or you are merely a user? Right, that's the key question now that we need to grapple with and we need to answer, right? So now let's look briefly back to what has been, right, from the 1450s until we get to the 2010s, right? So we know that we had printing press, right, where you would unauthorized production, you could not reproduce what the work that somebody else has done, right, because it belongs to the person who initially produced that work, right? Then we also had photography, right? Where a mechanical image is authorship, right? It will involve photography gained copyright because what determined ownership of that was the human choices, the posing that you do, the lighting, the composition, and all that constituted authorship, right? With AI now, the machine generates expressive content without equivalent human control. And the real question is no longer whether machine assist, but whether work generates works generated by the machine should be owned at all. Right. So copyright law is always, now what we see is that copyright law is always responded to technological disruptions, right? It always been trying to keep up with the technological disruptions, where the printing press raised concerns about unauthorized copying. You were not allowed to copy what somebody else has done, and that brought the issue of plagiarism. Then photography raised questions about mechanical assistance and authorship. Then software challenged the distinction between functional codes and literal work, right? That now we are in the issue of generative AI. Now Gen AI now challenges the meaning of creation itself, right? Previously, prior to AI, we were questioning how the expression of that work right now. But Gen AI has unsettled the whole matrix in that it is actually challenging the meaning of creation itself, because the creation of that work does not solely lie on an individual. Instead, it can be done in the absence of an individual. So photography became copyrightable because courts recognized human choices in composition, right? That's what gave photography the right to say, okay, this is a copyright a product, right? Because the courts gave the choices, they gave the rights to people who have said, oh, there was human interventions, the human choice in composition. How did you compose this image, right? The lighting that you have put in there, then the posing and arrangement, right? So AI is different because outputs may be generated with limited human control, and the issue is no longer simply whether machines assist creativity. The issue is whether machine generated expression should be owned. And key question is AI comparable to a camera, a pen, a ghostwriter, or an independent producer? How do we then situate AI within this all metrics? If we say you could own copyright because there was human intervention in the composition of the photography, right? Then what then does it mean when there is human also intervention, extremely engaged human intervention in the production of work that you generate from AI, right? So these are the key questions, and these are the issues that we constantly grappling with in our bid to answer what really does it mean, right? So, but let's look at human authorship and the foundation of copyright, right? Let's draw parallels from the USA, right? So the USA, uh, it is what copyright limited to. The copyright is specifically built around human authorship, right? And for them in the United States, copyright protects human creative expression, right? And purely machine generated works then therefore becomes difficult to protect. The United States, they have adopted a strict authorship approach, and the copyright office requires disclosure of all AI generated material in copyright in copyright in applications, right? There was a one case that is called the Tola litigation, right? It reinforced the view that AI cannot be treated as a legal author. So that's the basis. AI cannot be treated as a legal author in the USA, and AI assisted work may still then be protected where humans contribute meaningfully in the creative expression, right? That's what the copyright laws say in the United States. So what we see is that the aspect of ownership of work, right, is centered around human authorship. It's centered around human creative expression, right? So in the absence of human creative expression, where in a case where you just put a prompt, then the whole essay comes out or the whole paper comes out, then the issue of ownership then becomes into question. Now, whether you own this work or you do not own this work, but we'll answer that question, right? So the central issue is the threshold of human contribution when we're looking at what is happening in the USA. So we're looking at how much human input is enough to convert AI output into a copyrightable act, because we're saying that there should be meaningful human intervention and human creative expression in the work that AI has generated. So that's the basis, right? So we say now, to what extent, right? Do we then say your work or your human intervention in the creation of this work? How do you then prove to say I've spent so much work and so much hours? These are the prompts that I've used. these are the ABCD that I've put into this work so that it comes out to life. And you need to prove human creative expression. You need to prove maximum human intervention according to the United States. So the human creativity now is centered around 5 key pillars, right? The first one will be originality, and the second one is intentionality, and the third one is personality. The fourth one is judgment, human judgment, that is very, very important. And the skill and labor, skills that you bring into generation of this work that you are claiming to own, right? How much skill did you put into this assignment? How much skill did you put into this paper? How much skill and labor and knowledge and originality and judgment did you invested? If you can then prove that that was substantial, then you can be able to claim ownership of that work or copyright of that work, right? But let's look at the AI output problem, the creation, the predication, the prediction, or the recombination of work. So we're saying AI output raises a huge conceptual problem, right? Are they creative works? Right? Are they statistical predictions? Are they recombination of training data? Are they collaborative works between human beings and machines? Now, large language models generate outputs by predicting patterns, right? You are predicting a pattern that is probable to the most closest answer, right? You know, that they're doing, right? So they do not necessarily create with intention, right? With consciousness or moral responsibility. So this weakens AI claims that itself can be an author, right? Because it is not involved in the process of creating that information with intention. I always argue that AI platforms do not have objectives of their own, right? They do not have objectives of their own. They do not have consciousness, which is the ability to be self-aware, right? They're not, if we remove the human being, they are not aware of how they feel at a given time, right? They're not aware of the moral responsibility, except that that moral responsibility is brought in by the individual who's actually working on those platforms. So if we are saying this, the absence of the creative intention, consciousness, and moral responsibility, then weakens AI's claim to be an author, right? It then falls flat in terms of claiming for authorship. So it cannot, that work that it has generated, it cannot therefore go and claim that this work is, I'm the owner of this work, right? So human authorship then may arise where the user, right, designs the prompt carefully, right? So we're saying because the AI platform falls in terms of claiming for ownership of the work, the output that has come, we're saying the human author can therefore be able to claim for that ownership of that work, given that there is a strict design of a prompt that is carefully thought, right? Then they select outputs, then they edit the material, then they restructure the content, then they add analysis, then they apply judgment, then they transform the output, right? And this therefore brings the human author to have that confidence to claim that work, right? Because what it does is that it meets those 5 pillars that I spoke about: the personality, the judgment, the creative expression, right? It comes in through how have you designed your prompts, and how have you selected the outputs, not copying and pasting everything, and how have you edited the material, and how have you structured this content, and how have you added an analysis, and then ultimately adds judgment, and you apply your judgment and then transform that output not to be an AI generated output, but to be an AI assisted output, right? So we have one case, the study by Draxler Excel, that shows that users feel more ownership when they have greater control over the text, right? The key question is prompting alone enough to establish ownership. Right. That's a key question that we need to talk about. Now, if I have a carefully crafted prompt, right, like the prompts I use, right, when I'm doing my work, I very crafted prompt. I've mastered prompt engineering, right? So does that, having that prompt alone, qualifies me to claim for ownership and file for copyright? Right. So that's another question that we are still grappling with, that we need to look in and engage, because we have all those hanging questions that still the law does not address when we're talking about ownership of that work. Right, so let's briefly look at global comparison, where we look at the US. We've briefly touched on the US, the UK, the EU, and Africa, and then we go to South Africa. So the United States, we said it has strict human authorship laws, where it provides a clear human authorship model, where we say copyright protection is limited to human created expression, and AI cannot be registered as an author, right? Purely AI generated works are generally not copyrightable. They disregard them. This work is generated by AI. This song is generated by AI. This image is generated by AI. We don't copyright those. So no one claims ownership of that, right? Then AI assisted work now may be protected if the human contribution is sufficiently creative, right? So where we say protectable human contribution may include, right, when you prove selection, right? That is in the USA. When you prove arrangement, when you prove editing, when you prove transformation, when you prove creative direction, when you prove original additions, now the human model will provide that room for you to actually file for ownership of that work. However, it may underprotect valuable human AI collaborations, right? This model that they have in because when you fail to prove, right, even if you have done all the above, right, when the court still feels that what you have done is still not sufficient, it might disregard some valuable work, right, that needs to be protected, that needs ownership to be claimed, right, that has been generated by human AI collaboration. Now the key question is, should South Africa follow the strict US model or adopt a more flexible approach? Right. So when we look at the EU, right, the United Kingdom, has recognizes computer generated works, right, under the section 93 of the CPDA, right. The author is according to the act, the author is the person who made the arrangement necessary for creation, right? So this is an interesting one. What they are saying is that if you made the arrangement for creation, right, then
Wale
you
something
can,
like. I got it.
right, there's
Yeah.
one, sorry, there's
When you give me the
KO,
say prof
can
then
Oton, can you please mute your mic? Otun
can you have
Kaber,
me? Okay,
Otun
nah.
Kabe,
You can answer that because
Otun Kabe, can you please mute? Right. So the United Kingdom now, the issue of ownership now rests on the idea of saying the author is the person who made the arrangements necessary for the creation, right? And this complicates the whole discussion, right? Now, because this avoids automatically placing AI generated works in the public domain, right? However, it creates new uncertainty, right? So the arrangement necessary, as they put it, could refer to the user, right? You've also made the necessary arrangements by you subscribing to the platform, by you coming up with prompts. You've made necessary arrangements for the creation of that work, right? The developer of the platform, it also made arrangements necessary for the creation of that work, right? The platform owner themselves also made arrangement necessary for the creation of that work, right? The employer, if you are working for an institution, has made also arrangements necessary for the creation of the work, right? And the person who designed the workflow within the organization also has made necessary arrangement for the creation of the work. So the UK model is more flexible than the USA model because it tries to understand how the complex environment of AI and technologies work, right? But it still does not recognize AI itself as the author, right? This model is important for South Africa because South Africa copyright law has similar language on computer generated works, right? It's because it also speaks to the issue of, if you made necessary arrangements, right, for the creation of the work, you also can claim ownership. But there are more things that you need to prove. But the question is, who actually makes the necessary arrangements when generative AI is used? That's what has not been answered in the UK model and in the South African model. Who actually makes the sufficient necessary arrangements when generative AI used? Because we know that there is a matrix. There is the user, there is the developer, there is the platform owner, there is the employer, there is the client, and the person who has designed the workflow. All these people, they can claim to have done a necessary arrangement for the creation of this work that one would later claim after they've generated them from AI. Right? Let's look at the European model. Right? So European model is based on transparency over ownership. So Europe is increasingly focused on transparency and accountability. So the UAAI Act does not fully solve the copyright ownership of AI output. It rather addresses the upstream problem of training data. Right? So where it says general purpose AI providers might comply with copyright related obligations, right? They must also provide summaries of training content, right? This approach shifts attention to issues of disclosure, traceability, provenance, accountability, and rights holder protection, right? So instead of being worried about the issue of who has contributed to the generation of this work, they are most interested in the 5 key aspects: the disclosure, traceability, provenance, accountability, rights holder protection. So the EU model is relevant also to South Africa, because it suggests that AI reforms should not only ask who owns the output. Right, that's what we should not only be concerned about. It should also ask what was used to train the system itself. And the key question, however, remains: should South Africa regulate AI output, AI training data, or both? Right? Who should we regulate in this whole matrix? Right? When we're drawing on the UA model, right? So now let's move to the African context, right? Let's move to the African context and look at the copyright complexity of copyright ownership and human creators at the center within the African context. So the African copyright system generally remain human-centered, right? Most systems from Kenya, from Nigeria, from Ghana, and South Africa, they are human-centered, right? They protect original works created by natural or legal persons. That's what they regard to as, copyrightable work, or only can you claim ownership of that work. So AI itself is not generally recognized as an author within the African context, right? From our case studies. So Kenya has provisions relevant to the computer generated works. Nigeria's Copyright Act of 2022 does not regulate AI generated outputs. Is really silent about that. But Ghana and South Africa also remain grounded in your traditional ownership principles, where we put the human at the center of generating work. So the African debate now, what it needs to do is that it needs to go beyond technical copyright rules, right? It should rather, I suggest that it should address issues of indigenous knowledge, right? Cultural heritage, right? Local languages, right? Data coloniality, issues of unequal platform power, right? And benefit sharing, and African creative industry, right? Those are the issues that I think the African copyright system should rather look at, right? And they should look at the bigger picture, where AI ownership in Africa should also about cultural extraction, right? The issues of language resource and unequal power platforms. These should be treated very, very, very carefully, and should be considered within the issue of ownership of when we're talking about the AI generated output, right? We're asking ourselves, these indigenous knowledge systems that this platform has generated, From which community are they coming from? Right? From which cultural heritage are they coming from? From which local languages are they coming from? Right? And when we can establish that this is the source of all these indigenous knowledge systems, then that ownership should be co-owned between the person who is claiming ownership and those from whom the indigenous knowledge has been drawn from and has been copied from. Right? So, but the question remains, can then African copyright systems protect creators without allowing global AI companies to extract cultural and intellectual value without accountability? Right? You'd see that our indigenous knowledge system, for example, Ubuntu, right, it's full in AI, in generative AI platforms, right? But there's no way in any time, right, that ownership is accredited to African communities. Right. So we need to look at our copyright platforms or the issue of ownership to say, if these proverbs have been drawn from the Wakanda people, right, those people have a share ownership, right, of this kind of knowledge when it is generated from these AI platforms, right? So that's the level we need to go when we're talking about ownership of that knowledge within the African context, when we are talking about generative AI information and knowledge. Right. Let's look at South African copyright law and originality and what does it say about who owns the knowledge. Right. So South African Copyright Act 1998 of 1978 is the central legal framework in South Africa. Right. But what does it say? Even though the Act recognizes computer-generated works, right, for such works, the author is the person by whom the arrangement necessary for creation were undertaken. Right, the author of a computer-generated literary, musical, or artistic work or computer program is the person by whom the arrangements necessary for the creation of the work were undertaken. Right. So the originality threshold in South Africa was proven in a case between hard and soft copy versus Brewer's Marketing Intelligence. You might need to go and look at that case in that court case. Right, where the threshold of protectable substance and originality, it was said it must be met. Right. So for such works, the author is the person by whom the arrangement necessary for creation were undertaken. And that's what the South African law it says, right? So this appears to make South Africa closer to the US than to the UK than the US. But however, originality remains a major legal hurdle in South Africa, because South African law links originality to issues of skill, labor, judgment, effort, non-copying, and human contribution. Right? When you want to meet the the ownership or to claim ownership, the law says these are the things that you need to prove. Right? So in the case that I've already mentioned, the case of Hart versus Brewers Market Intelligence and Wild CC and First National Bank, right? These are very useful for discussing originality. Right. So the key uncertainty is whether a short prompt reflects enough skill and judgment. Right. That's the challenge that we are grappling with within the African and South African context. Does your prompt then give you enough rights, right, to claim ownership of that dissertation that you've generated? Does your carefully crafted prompt then meets the skill criteria or the skills test? Does it meet the labor's test? Does it meet the human judgment test? Does it meet the effort test? Does it meet the non-coping test? Does it meet the human contribution test? Right. So the key question is, can a prompt alone satisfy South Africa's originality requirement that is predicated on those key aspects? Right. So the challenge is, if AI output lacks human skill, labor judgment, it may fail the originality threshold entirely. And regardless of who prompted the system, that work might not qualify to be claimed for ownership by the one who is claiming ownership at the time at which they want to claim for ownership, according to the definition of ownership from the South African context. Right. So now, who owns AI outputs in South Africa? Let's talk about the decision flow. Now, this question it needs to be answered, but the question, the worry is, are we really going to get to an answer? Right. So the South African position is not fully settled. There is no answer to this question as yet. Right. Possible owners may include within the South African context, the user who enters the prompt may qualify as the owner of that work, right? The employer upon which, or the institution upon which that work has been generated might also claim ownership, right? The composition client, the commissioning client, right? If you're being paid to do the work, that client may also claim ownership of that work. The consultant may also claim ownership of the work. The AI developer may also claim ownership of that work. The platform provider may also claim ownership of that work. So no one can also claim ownership of that work if copyright does not subsist. Right. So if the work is created during employment, for instance, the employer may claim ownership. Right. If the work is created for a client, the contract should determine ownership. And if the human input is too limited, the output may fail the originality test or threshold, and AI-assisted work is more likely to be protected than fully autonomous, right? AI output. So contracts, therefore, are essential. And key question that we still has not found answers to: should South African law distinguish between AI-generated work and AI-assisted work, so that we can be able then to claim who or to whom does this work belong to? Right, that's where South Africa is. Right, so we're saying South Africa needs clear statutory guidance distinguishing AI assisted work from fully autonomous AI generated outputs. Right, so because as it stands and where we are right now, anybody can claim ownership of that work. Right, so the platform terms are not copyright law. Right, so I want to take you through what the platforms that we use, what do they say about claiming ownership of that work. Right, but the argument in this particular case is that platform terms are not copyright law. Right, you can they are not basis for you to go and claim for ownership. So AI platforms are important but not decisive. Right, a platform like ChatGPT assigns output rights to the users. Right, they say the output belongs to the user. Right, however, this now does not guarantee the copyright, that copyright exists. Right, so contractual rights and copyright rights are not the same. Right, contractual rights are the rights that you're having with the platform term, the platform owner, when you say I agree to the terms and conditions of the platform. Right, but we are saying they do not automatically translate to copyright rights. Right, so platform terms usually operate uh, subject to applicable laws. They are governed with laws within that particular context within their operating. So this means national copyright law remains decisive. Despite what ChatGPT says, it says that you own whatever that you have generated in this platform or in this work. Right, we need to be guided by the available laws and legislature about ownership within our particular country. Right, what platforms terms do is that they basically assign contractual rights between platform and user, and they state who can use the output commercially, and the limit they limit platform liability. They limit the liability of, if any harm happens, they are putting themselves outside of that liability. And OpenAI assigns those rights to users subject now to applicable laws. Then what platforms terms cannot do is that they cannot create statutory copyright where law denies it. They cannot override law or commissioning agreements. Right? They cannot substitute or cannot be substitute for legal ownership analysis, and they cannot resolve data protection or professional ethics. Right? So users should not rely on the platform terms. They should rather consider the copyright law within their country, the contract law, the employment rules, the data protection laws, the confidentiality, institutional policies, and professional ethics. Right. Now let's talk briefly about the ghostwriter or the AI ghostwriter effect. Right. So there is a debate and there is a huge discussion around the ideas of ghostwriter and the ghostwriter effect. There are key studies that were done. I'll take you through those studies and their findings. Right. There is a group of people who say, right, if you delegate your work to an AI platform, right, and they generate the entire essay, they generate the entire thesis, right? That's a ghostwriter, and AI has acted as a ghostwriter for you, right? And there are those who say, if you give your work to a human or to a consultancy, to an individual to do your work, right, you have delegated your work to a ghostwriter. Therefore, you cannot own ownership of that work. And in both contexts, they argue that you cannot we cannot own ownership of either work. And there are those who say, no, because I've paid for it, it belongs to mine. I can claim ownership for it because I have a contract with the platform developer, right? Therefore, this paper mill or this ghostwriter is working under the contracts or the contractual agreement that I have, right? So, but now what has research proven, and the studies that have been done, right? There was a study that was done by a scholar called Dextro, right, who identify what they say the AI ghostwriter effect, right? And the findings showed that users often do not feel that they fully own or other AI generated text, right? Even if they feel that the work that has been generated by AI, they do not own it or they do not fully have control over it, they still publicly declare that work as theirs and as them to have authored this work, right? They don't psychologically, they feel like AI has done this work for them, and they don't feel like they own it. But when they publish that work or they put it in public, they have confidence to say, I'm the author of this work, right? This then creates a gap between private perception and public attribution. Privately, they don't feel ownership, but publicly, they attribute themselves as owners, right? So this study found that users credited themselves even when AI generated text, right? They credited themselves even when AI generated the text, right? AI was credited less often than human ghostwriters, right? What happened is that the people who use human to write their work for them, they feel more confident to declare that a human being has assisted me to generate this work more than they feel that an AI platform has generated this work for me. They feel more ownership of that work when the work has been done by a human as opposed to that work has been done by a platform, right? So AI was credited less often than human ghostwriters, and greater user control increased perceived ownership, right? And disclosure improved when users were given clear authorship on options, right? And this has major implications for universities, publishers, research consultancies, journalism, and legal practices and corporate communication, right? You'd see that where there is low AI control, right, confidence to declare has been low, right? Perceived ownership by control level. Where there is medium AI control, confidence to declare the work at 54%, right? Where there's AI, high AI control, right? The prompter, right? It goes 74%, right? There's danger there, and confidence now rises at 91% when that work has been done by another human being, proving that the users of AI platforms still believe that ownership of the work can only be done or can be fully claimed when it is human-centered, right? So universities, students claim sole ownership of AI written work, even with they generated using AI platform, they feel that it doesn't belong to them, but they still claim it as their own work. Journalists publish AI generated copy under own bylines. Then research consultants pass off AI summaries as original analysis. And then ASI question is, what disclosure duties attach to AI assisted knowledge, right? The key question is, should disclosure of AI assisted be legally required or ethically expected within the South African context, right? Now, let's talk about the training data, the scraping, and the rights of original creators. So the ownership debate begins before the output is generated, right? So AI systems are trained on massive data set, right? Original creators, the books, the articles, the music, the codes, the legal codes, the docs, the cultural archives, right? Then the scraping and ingestion, right? Often without consent, licensing or compensation to authors, then AI model trainings, then the statistical patterns extracted from billions of human created works, then the AI output is new works that may commercially substitute original creators' work, right? So now, many creators argue that their work are used without consent or compensation in the process of scraping and ingestion. Right, this raises issues of copyright infringements, fair use of or fair dealing, licensing, marketing harm, attribution, and transparency. So in Africa, right, training data debates must also now include indigenous knowledge and local languages, right? And South Africa should consider whether AI developers must disclose training source, right? So how jurisdiction responds, right? US, you need to litigate and fair use debates, no AI specific training use rules in EU AI Act, right? The training content summarizes summary is required and transparent mandate. And in Africa, there is no adequate AI specific training data rules, and there's an urgent need for reform. And for South Africa, we're seeing local languages, the indigenous knowledges, right, the cultural expressions and academic outputs may be absorbed into global AI systems without meaningful benefit sharing or recognition. Right, but we still need to answer some key questions where we're saying, can AI companies lawfully generate value from creators' work without consent, payment, or recognition? We as knowledge creators, our articles are there online. They are being scrapped, our ideas are being taken, they're being summarized, and they are being given to other people, passed forward. Now, the question is, can AI companies lawfully then generate this value from creators? They are making money, we know, right, without concern, right? Do I consent for them to train their platforms on my data and the payments and recognition? So those are the key things that when we are generating policy and laws in South Africa, we need to actually look at. Right. So South African reforms question, right? Protection, disclosure, or public domain, the whole of South Africa. So we're saying South Africa or Africa, the African context, faces several reform options, right? Number one, the first option is to retain a strict human authorship model, right? Then the second option is to modernize, right, the computer generated works provision, right, to specify who makes the arrangement necessary and what degree of human control is required, right? Then the third option is to protect only AI assisted work with meaningful human input. The fourth option will be to place purely AI generated work in the public domain, right? And the fifth option is to introduce mandatory AI use disclosure, right? Like most universities have done that, most institutions have done that, most publishing houses have done that. Then the sixth option is to introduce mandatory AI use disclosure, right? And the sixth option is to regulate training data and benefit sharing, right? We're saying the platforms that are train our data, they need to be regulated and share the benefits or the proceeds from training their platforms on this data with the people who actually own the data, right? So any reform should therefore clarify who owns AI assisted outputs, and it should also clarify who owns computer-generated outputs. It should also clarify what level of human input is required for one to claim ownership, and whether AI use must be disclosed, right? And whether training data must be licensed. And how can African knowledge system be protected in these platforms, right? So the final question that I want to leave everybody with is, should Africa and South Africa protect AI outputs, protect human creators from AI, or design a hybrid framework, right? These are the key questions that we need to ask ourselves. Colleagues, we've come to the end of our presentation today. Thank you so much for taking time to listen, and I hope you've gained something on this key question and debate as to who owns AI knowledge or knowledge generated from AI outputs, right? I'm opening this platform now for questions, right, and discussions and comments from those who feel that they want to do that. Then we can always engage and hear where you stand. Thank you so much for your time. Let's hear some hands. I'm gonna check if we have comments in the chat. Right, colleagues, the floor is open if anybody wants to go. Any takers? Right, Taba Nkabinde, thank you so much. You can go ahead.
Good morning, Doctor, and everybody in this space. I have you have posed a big question, but I have a question before that one. That or that, and now that there are systems which are being designed, and we are using the system to access some other individuals' work. Even the internet was also doing that. I'm asking myself if the designer can now start claiming that the knowledge you produced after you have put your prompt, he must also take ownership or be half of the ownership. Then what about the knowledge which has been is being accessed? Because if then I have published and then when you scroll, you find my information. Sometimes when you ask for references, my reference is coming there. But then no, I was not consulted that that system or that machine or that app should, use my work. And then somebody is using my work, then somebody, now that he has this other app, is claiming the work. And then again, okay, maybe trying to answer your big question again, if I'm still in this space, is that, yes, I think South Africa can be looking at how we go about, like, as you were indicating, that other countries are now, like United States of America is now allowing, but they also need the author to state and declare and be very transparent about the usage of AI and bring in the human component through creating this and that. I think South Africa can follow suit, because as we are delaying to come into that space and come up with our copyright, obviously we are going to mimic, or we are going to, to replicate what others are doing. For a start, let's replicate that which is better in the system. Thereafter, then we continue coming up with something best. You also indicated that we also need to bring our information, indigenous knowledge systems. We need African and South African wisdom and knowledge to be cited. And maybe, I don't know how that will come into this space, because if these apps are coming from that other side of the ocean, including Mediterranean Sea, then we still have a problem. So we need to write and bring our own culture and bring the African wisdom in. Then we can now come to the space where we say, now we can need AI that which will only locate African information or global South information. Thank you.
All right, thank you so much. Interesting thoughts there. Thank you so much, Dr. Nkadibeng. Very key responses to what I was sharing. So you see, there's like I said, there are three schools of thought in terms of ownership of work, right? And we haven't agreed because we do not have yet the copyright law has not come to terms. What like as usual Africans, we are always lagging behind, right? We haven't updated our copyright laws since 2002, 2007. The technology came, 4IR came, the social media came, all those things came. We are not updating, right? We are always caught and unprepared, right? And that's where the predicament is. But I'll briefly run you through the key schools of thought that are there, and I'll emphasize the dominant one, right? So the first school of thought is the one that says the prompt, the user or prompt creator should own the output, right? Because what they've done is that you've brought in your intellectual direction, right? Otherwise, the developer of the platform and the platform itself would not have generated that information had you not brought in that prompt, right? So they argue that the platform is basically arranging that information according to your intellectual direction, right? So they also argue that you have framed the prompts and you edit and curate the output and exercise creative judgment. And this, therefore, ticks the boxes for ownership, right? Because the intellectual direction is coming from you, and then the prompts are designed by you, and then you edit and curate the output and exercise your judgment. So under this approach, what we see is that AI is treated like a tool, right? Or similar to a camera. Yeah, that's the argument they say. Do you say if you're using a camera and it's recording a video, right? Do you then come and say this video piece that we generated, the raw piece of video, an edited video, therefore belongs to the camera, to the Canon camera, right? That's the argument they are pushing there. But they say now ownership of that work, that video, is you are directing what the camera should do. Then when you're done, you go and edit, right? It also looks at the Photoshop, right? It looks of NVivo, those who are familiar with NVivo data analysis tools, or Microsoft Word. Can we say Microsoft Word owns the work that you have generated because you are simply typing your work on a Microsoft template, right? You are directing the intellectual direction. So many AI companies then adopt this position contractually. For example, OpenAI states in its policies that users generally, like I've already said, right? The strength of this position is in four ways, right? It is strong in four ways, I should say, because number one, it encourages innovation and adoption, right? It allows people to innovate, to create, do whatever they want to do with the platform without thinking about the parameters of whether I don't own this or not. Because if you feel ownership of the platform, of the output, you can come up with serious prompts to get the best out of the platform. It also encourages adoption, and it supports creative industries. It gives business legal certainty to say we are protected, this work is ours, and it aligns with traditional notions of ownership through human direction. So basically, the first position of user or prompt designer owns the work, owns the output. It actually aligns with your traditional notions of ownership because everything that is coming out is directed through the human work, right? But it has weaknesses, of course, and some of the weaknesses that the AI system contributes substantially to the final work. We cannot draw a line there, right? So the second one will be AI companies should own the work, but output, but I don't think it's a strong one because we're arguing that they created the architecture, right? This comes into conflict, or this may resonate with the South African copyright law, that says you need to prove that you've made necessary arrangements for the creation of that work. And these guys argue that we have created the architecture for the work to happen. We have supplied computational infrastructure. We've trained the model on vast data set. We've enabled the generation of the process. And this resembles software licensing, right? So it's one of those. And there are those who say nobody should fully own pure AI output. There are those who say that because they say a third perspective. They say that no one is full autonomous, right? That fully autonomous AI generated content should belong to the public domain, because copyright law traditionally protects human authorship. So there's no human authorship here. So that work that you produce, it belongs to everybody, can use it. And we're saying AI lacks legal personhood, right? And machines cannot hold intellectual rights. So this position has gained traction in courts and copyright offices. It's gained traction, right? In US, some quarters are approving it and are buying the idea, right? So there's the last group that believes in collective ownership of work, right? So they say, if my article as an author is cited in that output, right, I need to have some benefits, some money there from the platform. They must pay me whenever my article is cited, or whenever my work is cited, or whenever comes out in the output that has been generated. So I also need to have. So we're basically saying, let's share the benefits. We have the prompt creator gets the output, then we have the AI company gets the subscription, and the creators of the data that is trained on the platform. If your data is used by this platform, you should, if or your book, if your journalism, your article, your artwork, your academic publications and online content is scraped and included in the output, you must be given some monies from there, right? So writers organizations, publishers and musicians are pushing for this one. They say this is what we need, right? But what does it mean? What is happening in academia? We're saying in academia, those of us who are in academia, the dominant emerging consensus is that we agree that AI cannot be an author, right? And we say humans remain accountable for the intellectual work, but AI use should be disclosed transparently. And that's what we are saying within the academic space. So that's where we are in terms of who owns, right? We haven't settled yet because the law is behind. We haven't settled yet. And most of whether who becomes the owner is regulated by institutional frameworks and policies for now, right? Because we still do not have the laws that actually settles this discussion and these debates. Right. Thank you so much, Dr. Kabin Nkadibeng. Right. I hope I answered that effectively. Let's hear from others.
Yes, thank you. Thank you very much, Doctor.
All right. Any other comments, colleagues? Any other comments? All right. If there is none, then I think we've come to the end of our Saturday 16 May edition. Oh, there's one, Chinyama. There you go.
Yes, Doc. Thank you so much, Doc, for a wonderful presentation.
Yes, I appreciate it.
Yes. Now, I just have a question, Doc, because sometimes when I write my content without even using AI, sometimes it is flagged. When you put it on Turnitin, and it is then flagged as AI generated. So I don't know how, is there a time where Turnitin can actually maybe be in a position to actually identify content that has been human generated and that has been AI generated, or because sometimes I get so much frustrated and confused to say, then here, what should I do?
you so much for a very important question. So this one here brings us to the question of AI detectors, right? We know from research that AI detectors in and in themselves are not effective, right? So Turnitin predates AI, right? It existed before generative AI, and Turnitin, as we know, it is not intelligent. Right, it doesn't have intelligence. What it does is it picks up similarities and indexes. It cannot determine or decide whether work has been produced using AI. Right, what it does, it picks up some patterns in the work that then it attributes to similar to what AI generates. Right, and that makes it a flawed system. Why am I saying that? Is because when you upload your human generated content on an AI platform, right, on 1018, right, it's human work generated, right. 1018 doesn't identify if the work was human generated or not. It identifies similar patterns to work that has been generated by AI. I'm not sure if I'm making my point clear. Right? It doesn't have intelligence to determine where did the work originated from. What it does is to pick similarities and patterns. Then it therefore says, oh, the way you have structured this sentence, it's similar to what AI does. Therefore, this is AI generated text. Right. So if you write like if you as a human, you spend sleepless nights typing your work, right? Your own work, you didn't use any AI. But if your work has patterns that are similar to what Turnitin attributes to AI patterns, you still be identified or you still be flagged for AI. So it hasn't got to the point of saying, oh, okay, this work here, even if there are patterns that are similar to those of AI, right? This work, I can rest assured it was handwritten or it was typed by the individual themselves. And that's the fallacy of AI detection tools. That's why universities are discarding them. I know some institutions are still using AI to detect student work, but that should not be used as the basis to punish or to disregard a student's work, because we know that from research that has been done, Turnitin and other AI detection tools produce what we call false positives. Right, and these false positives, I always give an example that my PhD thesis that I authored in 2019 before generative AI, when I put it on Turnitin, right, it scored above 45% AI generated. And I got worried and I was, what might have happened? And I picked up that because I edited my thesis using Grammarly, and anything that is edited with Grammarly converts to AI generated text. So we are in a fix, right? So what needs to be done is that we need to tread carefully when we are actually examining students' work using this AI platform, right? Let's hear that.
All right. Thank you very much, sir, about the presentation. It was very informative. And then now my question is regarding the prompting of the AI. We know that even though our copyrights are not updated to a point whereby they accommodate the use of AI, but then our universities, they have like policies on the ethical use of AI. And then now, when we use our prompts, like you said, that when you prompt the AI system, then the output, it belongs to you. It's like it's your intellectual property. So is prompting the AI system in your own intellectual direction according to your discipline considered as an AI and as an ethical use of AI?
Okay, thank you so much. I was following, but I didn't get the actual question, the last part of what. Just briefly, what is the question?
Okay, the question is prompting the AI in your own intellectual direction. according to your discipline, considered as an ethical use of AI?
Yes. So yes, yes and no, right? So we say that prompting only, right, should not qualify as the ethical use of AI, right? Right. Well, we need to agree on determine the intensity or the effectiveness of your prompt or the prompt that you have developed, right? If your prompt can prove that there is human judgment, creativity, and originality, right, that is being prompted, and if that prompt is that effective, right, then we can safely say no, this is ethical use, right? But the issue of ethical use of AI does not end with the prompt, right? And this should be taken note of. The ethical use and responsible use of AI goes beyond the prompt, right, to the output, right? And after the output, it proceeds to go to the issue of verification, right? And it doesn't end with the verification, it goes to transparency, right? And beyond transparency, it goes to the issue of disclosure, right? So when the ethics of AI, it's underpinned by four fundamental aspects, right? Number one is intellectual originality, right? Then curation of the output, right? Then biases and hallucinations. Have they been removed? Have they been verified? Then verification becomes a key pillar, right? Then after verification and human judgment has been practiced, then the last thing is disclosure. That package makes ethical use and responsible use of AI. If you cannot prove, if you are a student or you're a PhD student or you're an author or a writer or an academic, if you're called to question, right? If you cannot prove these metrics, if you cannot prove that you have your prompt is originality in it, right? And if you cannot prove that you have curated the output and edited the output and to turn it towards your intellectual discipline, like you said, and if you cannot prove that there was verification of sources that was done and the claims are verified, right? If you cannot prove that if you cannot disclose, right, and if you cannot prove human judgment in this work, you are likely to be at fault in terms of ethical use of AI, right? And that's one thing that most students, when they are called to question, they fall short, right? I know a lot of students that have come to me. I know a lot of academics that have come to me asking me, well, what then do we draw the line to ethical use of AI, right? My prompt speaks about the discipline, right? So just the outcome that comes out, no matter how beautiful it is, no matter how beautiful that sounds, right? If that outcome cannot be proved to have been verified by you as an prompter or as a user of the platform, that outcome or that work falls. It fails to meet the criteria of ethical use of AI because you skipped the issue of verification, you skipped the issue of human oversight, of curation, you skipped the process of verifying claims and citations, right? And you didn't disclose, right? But if you tick all the boxes, then ethical and responsible use of AI has been done. All right, thank you. Hope that answered your question, Lesego. All right.
Yes, sir. Thank you.
Okay, I appreciate it. Any other comments? Any other comments, thoughts, or ideas? Colleagues from Durban, from M&G Research. Any thoughts? Any concluding thoughts?
I can see there is a comment in the chat box.
In the chat. Okay, I'm gonna have a look quickly.
Okay,
So
the comment is already. Okay, so.
Okay, my chat is not loading. I don't know what's happening here. What is the comment? I can't. My chat is not loading, unfortunately.
Okay, is Busiso still around? Or I can read it?
Yeah, you can read it, sure, no problem.
Okay, so it is saying, interestingly, we live in a world where AI is listed as an author in journals in the West, and conversely, in the global South, authorship is determined by effort. How credible are the journal articles with AI as a lead author? Interesting times, particularly in the academic space.
Well, I'm not sure about the merits of those comments, because what I know, right, in the Western countries, in Europe and in the USA, already AI cannot be regarded as an author. You can't list AI as an author because it doesn't meet the criteria of authorship, right? It doesn't meet. We say it doesn't have consciousness. It doesn't have human creativity. It doesn't have judgment, right? It doesn't have intellectual creativity and all that, right? So it doesn't meet the criteria of authorship, right? So I'm not sure. I would love for Busiso to have an engagement with Busiso to share with me some of those journals that you have seen, right? That AI is listed in as an author, because that shouldn't be happening. We're drawing on the legal framework in the EU, right, and the United States of America. So I'm not so sure which Western countries he's referring to. Maybe we might need to have that conversation and see those examples. Right. Any other comments, colleagues? Dr. James, I see you are here. I'm not sure if Dr. Gilbert is here. Right. Any comments, Dr. James? All right. That
No,
doesn't
thank you
seem.
very much, Doc.
Yes.
I was following. I think you've addressed particularly most of the contentious issues that we are finding insofar as copyright and AI is concerned. I think from my side, I'm covered, and thank you very much for an insightful presentation.
All right, appreciate it. Thank you so much. Dr. James is going to be joining us in one of these presentations when we're talking about. Okay, there's Tony Monty. You can go ahead, Tony.
Good morning, and thank you very much for a very insightful presentation. Indeed, we are in a new world. I'm not really sure if my comment is really directly AI related, but I'm just wondering if it certainly is worthy of a further future discussion. And that was your discussion around the school of thought about shared IP when citing authors, academics in an academic work. And I think that is very interesting and very complicated, and certainly worthy of some robust discussion. So that was really just a comment more than anything else. It's not really directly AI related. I don't think this is something that is a new. It's not new, but obviously with AI, it's becoming more prevalent. And yeah, certainly worthy of a future discussion. Thank you very much for the presentation.
Appreciate it, Tony, for such rebut for bringing that up. I don't know where I stand also in terms of regards to, I'm an academic, to say, should I then get, well, that's what academics are saying. Actually, they want some to be paid for whenever, like what they do with radio, when your music is played on radio or when your song is played on radio, you get those commissions and stuff like that, per song. And with the argument is that the radio is making money out of listenership, right, from your music. And this school of thought is arguing that because you're making the platforms themselves, they're making money out of subscription, right? And the creative industry is also making money out of the output that they've generated. And now what happens to the middle person whose work is being used, has been scraped and synthesized to produce this final output? So as academics, we're saying we also need a fair share. We need our share in that whole matrix, right? We need our share in the matrix. Whether that's going to be possible or not, we don't know, right? But really, thank you so much for that, Tony. Right. I'm not sure if there is any other comments and hands, right? If there is none, colleagues, that means we've come to the end of this presentation. We are here again next week, Saturday at 10 a.m. on the same time and same place, talking all things AI. And what then does it mean for us to live within this place of AI? Thank you so much, colleagues, for your time. You know that you have a busy schedules, but you make time to come and engage with us on this platform. Right. Have a good day and enjoy the rest of the day. Bye-bye.
Bye-bye.